Right, it looks like most people are in from the waiting room, so I think we'll kick off. Welcome to Landmark Chambers Planning High Court Challenges Part 2. We're very pleased to see so many people joining us, and I hope that you find the presentations and the pack that you'll be receiving by email later on informative and helpful. And I also hope we can have a animated discussion at the end in a question and answer session on various issues that will be raised through these talks. The third part of the talk this series of seminars will happen next Monday, the 27th. There's still availability. All you need to do is go onto our website and click on the resources events page where you can book in for that. I'm Dave Forsdick. I'm going to chair today's session and be the moderator for the question and answer session later on. I'm joined by 5 colleagues: Jenny Wigley KC, Dan Kolinsky KC, Nick Grant, Siân McGibbon, and Alex Shattock, who I'm going to formally introduce you to in a moment. But first of all, a few short housekeeping points. First of all, your microphones will automatically be muted. So you don't need to adjust your local settings at all for the whole period of this seminar. We very much welcome questions. I've already had a few questions in advance. Please submit your questions via the question and answer box at the bottom of your, I think it should be at the bottom of your screen. If you'd like to remain anonymous, then you just tick the send anonymously box. Whilst the speakers are speaking, I'll be collating the questions and try to make sure that at the end of the session, in the question and answer session, we have a wide range of questions that have been raised. The webinar is being recorded, and you will receive a link to the presentation and the recording shortly after the event concludes, with all of the slides, which I know some people watching this will find helpful. If your connection is lost at any point during the webinar, all you have to do is rejoin the meeting by clicking the original link once more. So that's the housekeeping. So let's begin. And let me start by introducing our 5 speakers. First of all, Jenny Wigley KC. Will be speaking and giving us an update on recent Planning Act challenges. As many of you know, she's very experienced in judicial review and statutory reviews for claimants, developers, and public authorities, and has acted in a large number of local plan challenges and similar DCO type situations. And directories call her a force to be reckoned with. So we look forward to hearing from her in a while. Dan Kolinsky, King of Counsel, is talking on NHS contributions in the light of the Leicester case. As you'll know, he's a very experienced senior courts advocate, including in the Supreme Court, and he sits as a Deputy High Court Judge and recorder. And he acts in the planning courts and in other courts for the full range, from local planning authorities, developers, central government departments, and action groups. Siân is a new addition to Landmark Chambers earlier in the year. We're delighted that she's rapidly getting herself established with her feet firmly under the table, and she's described as a rising star in the planning and environmental law world in the directories. And her practice is really in the intersection between public planning and environmental law. Alex Shattock also specialises in planning and environmental law, along with the public law aspects of that. He's acted in some of the really quite crunch cases of recent times, including the Cumbria coal mining case, the Bibby Stockholm planning challenge, and the Aylesbury estate challenge. He does a lot of work for NGOs and will be dealing with environmental impact assessment and SEAs for us. Nick Grant is a planning and environmental specialist. Again, many of you will know him. His CV reads like the list of the main cases going through the courts at the moment, Finch and Fry being the most obvious ones that jump out. And again, he's highly rated in all the directories. He'll be talking about issues on on granting consent to judgment and redetermination in planning High Court challenges. That's those are our speakers. The first speaker is Alex Shattock, and he's going to be talking on EIA and SEA cases and looking forward to the statutory changes which we're going to be faced with very shortly. Alex, over to you.
Hi everyone, got that working. Firstly, my apologies. I'm a bit under the weather today, so I'm not usually this deep and gravelly, but it might be an improvement. Who knows? Hello to all 400 of you, 400 people. Very much the Glastonbury of planning law updates today, and I shall be your Carly Rae Jepsen this morning. This is the EIA and SEA case law review of the year. The Levelling Up and Regeneration Bill, the LERB, has passed its law, and you know what that means: Environmental Outcomes Reports, EORs, or EoRs, as they say in the 100-acre wood. No more EIA, no more SEA. So this is probably the last ever EIA and SEA case law review of the year. It's the last one ever. I've had a lot of these over the years at Landmark Chambers. We like an SEA update. We like an EIA update as well, even better when they're together, a double bill of environmental impact assessment goodness. But I'm afraid that this is almost certainly the last EIA and SEA case law update ever, now that the Levelling Up and Regeneration Bill has passed. After this year, I would be frankly staggered if there was any more case law on EIA or SEA ever again. It's just not going to happen, is it? And so it's a heavy burden for me having to give the last ever EIA and SEA case law review of the year. If it was the last but one, the penultimate one, there'd be slightly less pressure, but this is the last one. But never mind, boy oh boy, are we going out with a bang this final year of EIA and SEA. It's been a wild year, colleagues, when it comes to EIA and SEA case law, an emotional roller coaster. There have been thrills and chills. Here are the cases we will cover, some great cases here, expertly curated. And before you ask, I'm not talking about Finch because we don't know the answer yet. Let's get started. Tewkesbury first, the first case in this last ever EIA and SEA case law review of the year. One of my all-time favourite cases, this one, chef's kiss. This is the Bridge to Nowhere case. You had a bridge. Where was it going? To a housing development that could not exist without the bridge. Were they the same project for EIA purposes? Well, is my middle name Ignatius? Absolutely yes, no doubt about it. And we all know the reason why. European Union derived environmental law doesn't mind salami. It would probably prefer a vegetarian alternative. It doesn't mind salami though, as long as you don't slice it. Salami slicing is a big no-no. And if you take into account the environmental benefits of this housing scheme, when considering the bridge, as happened here, pretty obvious, you need to consider the disbenefits too. If you want the salami, you have to eat all of it, no slicing. I'm getting kind of hungry now, but let's move to another case in our EIA and SEA case law review of the year. Hardcastle, a challenge to a housing scheme. This one, EIA was screened out. Oh yes, it's a screening challenge. Did this screening challenge succeed? Well, was Carly Rae Jepsen's latest album released last year? The answer is no, of course not. Carly Rae Jepsen has a new album released in July of this year, The Loveliest Time. Very much a companion piece to last year's The Loneliest Time, and a bracingly direct meditation on longing and desire. She's an artist who, like UK environmental case law, is evolving all the time. Where was I? The legal challenge, yes. Hardcastle, it failed. Here's why. You don't have to revisit an older scoping opinion if there's no realistic prospect of a different outcome, as was established in Lionbrook. So amend away. And on cumulative effects, you do need some evidence that it would have made a difference if the thing that was omitted hadn't been omitted. Makes no difference point. We'll come back to this. Another little point. A failure to use the exact language of the regulations is not fatal to the decision maker, not fatal to the decision if the decision maker did what the decision maker had to do. And if you do claimant cases, if you run points like this, it's just an invitation to use everyone's favorite opener to the summary grounds of defense. This is yet another example of excessive legalism and hypercritical scrutiny that the courts have long deprecated. As Lord Justice Lindblom said in St. Modwen, etc., defendants are still going to open with that. I can recite that opening paragraph in my sleep now, but please don't encourage it by running bad points. The next case, Bristol Airport. This case will be discussed later on this morning, so I'm only going to talk about the EIA points here. This was a challenge to the expansion of Bristol Airport. Alex, was there maybe some climate change type arguments in this case? Alex, you are a genius. Yes, there were. Firstly, it was said the environmental statement was flawed. Why was it said to be flawed? Because it gave local carbon budgets, no weight. There is no, and the court said that's okay. That's at least rational. There's no set approach to assessing climate change impacts, and omitting the local budgets does make sense. Climate change doesn't only affect one part of the world, it affects the whole world, not just regions. I'll return to this theme when we look at what the government says about EORs. The other issue in this case, or the other EIA issue in this case, was taking into account non-CO2 emissions. And of course, a planning authority or inspectors conclude, or Secretary of State's conclusion that an environmental statement is compliant with the regulations. That's a matter of planning judgment. There has to be a patent defect in the ES, see the Squire case, and the approach to non-CO2 emissions was not a patent defect here because of the lack of a scientific consensus on how you deal with those kind of emissions. Plus, as a bonus, these emissions could be dealt with via an action plan secured by condition. That was the plan. So overall, not successful, the arguments in that case. Next case, frack-free Balcombe is the fourth case. I think it's the fourth case in our 5-course tasting menu. This was a challenge to the grant of planning permission for a hydrocarbon well. There are lots of grounds, smorgasbord of grounds, but one EIA ground I want to focus on as part of this, our last ever EIA and SEA case law update. It's about flaring. Kind of interesting this. So when you extract natural gas, methane, some of it escapes. Yeah, and it's actually, for magical science reasons, better to burn it than to let the methane seep directly into the atmosphere. When you burn it, it becomes CO2, which, as I understand it, isn't as bad as the same amount of methane. Methane's pretty bad. I think 25% of global warming is caused by methane. Turkmenistan is really bad for this. They let an appalling amount of methane leak into the atmosphere without flaring it. It's pretty dire. But even flaring causes emissions. And the question in this case was whether the flaring emissions were considered. And you'll see the little quote on the screen there. Court was perhaps a little generous here, in my view. I think Jenny was in it, so maybe she can tell me if she disagrees. It says there's no direct mention of any of this flaring stuff in the ES, but was it really that bad? It's not Turkmenistan, is it? The court didn't actually say that. That's just my gloss. The court said it's unlikely this would have tipped it into EIA development territory. So again, makes no difference. Or so the court said. Always worth bearing that in mind when you have a good point. You've spotted an error. Brilliant. Let's go to court. Well, where does this actually go? Does it make a difference? And if it wouldn't make a difference, you're not going to win. And finally, for dessert, we have Greenpeace and Uplift, 2 claims about oil and gas licensing. And it was a Finch-esque argument, Finch inspo. It says your SCA needs to consider scope-free emissions, the refinement, and the combustion of the end product. Can you guess what happened? Well, the judge said, applying the Court of Appeal in Finch, it's all judgment, contrasting, of course, with the High Court in Finch. It's not irrational to scope this out because it's far removed what happens at the end stage. Oil might be burnt in a different country elsewhere. SEA doesn't cover everything. See all the case law on that, Buckinghamshire, etc. So overall, it's fine. Don't need to consider scope free. Will a decision like this survive Finch in the Supreme Court if there's a surprise reversal? Possibly not. We'll just have to see. Just that slide just sets out what I just said. Yeah, and so here are the sort of takeaways on this slide from those cases, what we've learned this year. Makes no difference point, always very important, but sunk a couple of cases this year. Excessive legalism, whether that critique is rightly made out or not, always try and avoid being too pernickety, bigger picture. And yeah, don't forget EIA and SEA, they're not intended to cover everything, as I've discovered in other cases. So you can only rely on that to a certain extent. The other thing as well, scientific uncertainty, that works in the decision maker's favor. See the mock case. If you don't know what the answer is, then you're entitled to rely on your scientists. As long as you haven't done a, completely bonkers analysis, you'll be fine. Right, so those were our cases. On to EoRs, EoRs, however you want to call them. And you'll see on this slide, if you've been alienated by the numerous references to Carly Rae Jepsen on the previous slides, I've put a little talking heads reference in there on here just to be inclusive. The government consulted on EoRs earlier this year, and gave us a bit more detail on their plans. Here's what the consultation document says. Leaving the European Union gives us a once-in-a-lifetime, that's your talking heads reference, opportunity to create an improved framework of environmental assessment which properly reflects our country's needs and the unique characteristics of our environment. The unique characteristics of our environment. That's interesting because, of course, our environment is uniquely British with uniquely British environmental problems. As we know, our air pollution is uniquely British. Our sewage pollution is uniquely British. Discarded tea bags, wet wipes, and broken dreams, uniquely British pollution. But putting that to one side for a moment, the key thing is, bottom of that slide, EoRs will be a simplified version of EIA and SEA, less to do and potentially less to assess. Here are the issues they want to address: inefficiency, duplication, risk aversion, loss of focus, issues with data. How does it work? Well, secondary legislation will set what the outcomes will be, which you need to assess your plans, projects against, with more detail in guidance. We don't know what they'll be yet. We have been promised a consultation, though, on what those outcomes should be. And here's the skeleton of what an EOR will look like, or likely skeleton. Still don't really know. You've got your reasonable alternatives, how you contribute to achieving the outcome, cumulative effects of the project, but only on the specified outcome. So it could be quite similar to EIA. Certainly you could design an EOR scheme that's very similar to EIA. If lots of outcomes, lots of requirements are put in place. Could be quite different though. I suspect it will be narrower, and my bet is they'll try and remove social, public health outcomes, etc. That's my guess. They are concerned about screening in EIA at the moment. Not sure why though. We've seen just this year a screening challenge fail. It's quite hard to bring a screening challenge. But they want to be more prescriptive about how borderline cases are considered. Now, if the aim of that is to avoid legal challenge, I'm not sure that's going to help, because then you just argue in court about what is and is not a borderline case. Lawyers, like life, although very different, will find a way. And it might also be that if you're miles away from sensitive receptors, you don't need to do an assessment, or you can do a less stringent assessment. a little troubling perhaps, but we'll see what the proposals say. Not all doom and gloom though, some good stuff here in the consultation as well. More monitoring, good requirement, we like more monitoring. Please can local authorities have some more money to do this though. Data for everyone as well. Same kind of data, publicly available data that can be used and compiled. All good. Also, please, can you give local authorities some more money to implement this? Overall, though, on EoRs, I'm not against change. I'm just deeply suspicious of it, particularly when we already have a mature regime of environmental assessment. Headline is, on EoRs, we don't know how stripped back this process will be. Doesn't need to be that stripped back, might not be to start with. The issue for me though is that the new act, the LURB or LURA as we now have to call it, it does provide for a series of powers which does allow a future government, maybe not this one, a future government to roll back environmental assessment via secondary legislation. Probably won't happen straight away, but we saw something similar with permitted development rights. All it takes is some bright spark to get the idea, and if there aren't appropriate safeguards in place, then you're in trouble. So I don't think this will be so bad straight away, particularly if there are detailed outcomes. Might be quite similar to what we have at the moment. But the idea that the whole framework only needs to be set out in secondary legislation, topped up by guidance, this does lay the foundations for some pretty radical environmental deregulation in the future, if there was a future government who wanted to do that, which I have to say does concern me. That's it on EoRs. Thank you very much for listening. I'll now pass over to my colleague and Chambers roommate, Nick Grant.
Good morning, and thank you very much, Alex. As slides make clear, I'll be talking about two issues today. One, the issues arising around consenting to judgment, and then the next is redetermination. So starting with consent orders, there are a number of requirements for these. They're set out in the admin court guide. I just flagged them because I've been asked to advise on them relatively recently, and so it's useful to have that signpost. You'll need an agreed draft order with a short statement of matters relied on, and any authorities or statutory provisions. That order, as we'll come to in a moment, has to be signed by all parties, including interested parties, and it should make provision for costs, or there'll be a deemed award, most probably no order as to costs. Unlike ordinary civil litigation, when you're dealing with a decision of the High Court, quashing a public law decision, the court itself still has to be satisfied that the order should be made. That could require a hearing. It could require consideration of whether there needs to be public access to the documents. And in fact, we've seen fairly recently a couple of the High Court handing down and making public the reasons underlying the consent orders that the court has been satisfied that it's right to make. And just as a reminder to anyone involved, you should, of course, inform the court as soon as possible if you become aware of the possibility of settlement. So turning then to the particular issues that apply or that can arise when you're negotiating a consent order. The main one, if you're the claimant, is do you fight on? If you've brought a claim based on 5 grounds and is not unusual, the Secretary of State or the local planning authority says you can have half of ground 1 and that's enough to concede, but everything else is absolutely rubbish. Do you fight on or do you take the win? This is a difficult balancing exercise in each case. The courts generally don't like academic challenges, and that's those that no longer directly affect the rights and obligations of parties. And if your defendant has conceded, then arguably anything else is academic. But it's not a never. It's not a never. If the issues are really important, the court may want to continue to hear them anyway. This happened in the Save Britain's Heritage case, not a consent order case, but a general will consider the issues that might be academic. And there are cases where the courts have said, okay, I appreciate that the Secretary of State is going to concede on a ground, but actually, before this goes for redetermination, we need to bottom out grounds 1, 2, and 5. And this D2M Solutions, which you've got on the slide, was such an example. The background basically is the applicant had applied for planning permission for a wind turbine, at a time when the feed-in tariff was pretty generous. That was refused. He JR'd it successfully. That got quashed, went back to PINS. PINS appointed a new inspector. The inspector allowed the appeal and reached different views on things like heritage impact, amenity, etc. So the claimant brought a claim against PINS. They've got an ex gratia scheme for those who suffer financial loss, saying, I would like some compensation, and I would like that compensation to include the difference in feed-in tariffs between what it would have been and what I will get now. And that wasn't insignificant. That came to about 2.3 million. PINS came back with a much lower offer, and that was reviewed on 4 grounds. One was that PINS had misinterpreted its own policy around ex gratia payments, and that the policy actually did provide for the difference in feed-in tariffs to be compensatable. 2, that PINS had failed to deal with the part of its scheme where they also allow for goodwill payments. 3 was whether certain other costs were within the scheme, and 4 related to Article 1, Protocol 1. Now, PINS conceded that it, or DLUC, I should say, had conceded that it hadn't properly dealt with ground 2, which is the part of the PINS scheme that deals with goodwill payments. But it said, don't worry about everything else, we're fine. Holgate granted permission for the rest of the claim to proceed explicitly on the basis that it needed to be resolved before the matter came back to redetermination. So where does that leave claimants? There isn't a hard and fast answer. I don't think it's going to be a balancing case in every case, because of course, if you try and fight on and the court thinks it's not worth doing, that can sound in both whether you get permission, and that will in turn sound in costs. So the real question is, I suppose, if it's going back for redetermination, do you really, really need it resolved? Something like a question of policy might well be. If you've got a number of grounds that realistically are just trying to re-argue the merits, you probably don't need those being reconsidered before redetermination. So you'll have to take a view in every case. Second key issue that arises is what happens if D1 says, yeah, okay, I'll concede, but the second defendant, if it's a 288 claim, or the interested party, if it's a JR, wants to fight on. Well, the honest answer is if given that consent orders have to be signed by all parties, if a second defendant or an interested party won't concede, it can't be a true consent order, so you can't actually settle the litigation. There has been a case in the non-planning context, which is the Reading case, where effectively the interested party was given time to object in writing to the consent order and was seen as enjoying a right to insist on an oral hearing. In my experience, what generally happens is the parties, claimant and D1, tend to hand up a draft consent order, or an order that says this is what we'd be agreeing. And then if it needs to go to a full hearing, it's down on the interested party to try and defend the claim, or at least defend their reasons why it shouldn't be settled. In the rarer circumstances where the first defendant doesn't want to concede but wants to play no part in the claim for financial reasons, something that we've seen before, something that we're probably going to see more given what's in the news at the moment about a number of local authorities being concerned about their budgets. That doesn't let them off the hook completely. The Mid-Counties Cooperative case from 2015, the court considered this and made clear that the first defendant, in that case a district council, still had to consider compliance with its duty of candour, still had to consider that required filing a witness statement and an acknowledgement of service with summary grounds, even if it's in outline form, and whether a representative didn't need to be a barrister, but whether a representative needed to be present so that A, the authority knew what was happening and could respond quickly, and B, answer questions asked by the court and take any other steps that arose. As to costs, when you're consenting, this can often be a situation where, or costs can often be the last stumbling block. Again, there's guidance in the admin court guide that references a costs note from 2016. For those who've been in this field for a while, that won't come as a surprise. But basically, parties should try and settle it first. There are some clear principles set out in Croydon and Tesfaye, which the court will be expecting you to apply. A claimant who obtains all their relief is a successful party and should normally get their costs. If the claimant obtains some of the relief, then consider how reasonable it would have been of them to pursue on the unsuccessful claims, how important those are, how much costs have been increased as a result of the unsuccessful claim. And if the court can't easily determine those things, then no order as to costs tends to be where it will net out. If the parties settle on totally different terms, which they sometimes do, then there's an even stronger argument for no order as to costs. And just to be clear, getting an authority to reconsider a decision that's been made, less so if you're challenging a planning permission, because obviously that needs quashing, but if you're trying to JR, for example, a decision whether to take enforcement action, just obtaining that reconsideration will often be seen as being successful. So those are the main issues that arise in consent orders. Then moving on now to redetermination and the issues that can arise there. Any redetermination in planning matters tends to arise under the inquiry's procedure rules. Rule 19 provides that the Secretary of State shall send those who appeared at inquiry a statement of matters on which further representations are invited, shall give those same persons the opportunity to make written reps on those matters, i.e. explicitly linked to the matters on which further reps are invited, and then may reopen the inquiry either with the same or a different inspector. And just as a headline point, the written reps are to be received within 3 weeks. That's something that's set out in statute. It's not the Secretary of State being unreasonably short. So the main issue that arises is what is the scope of the representations to be made? And this kind of feeds into the point that I previously made about what happens if you think there are a whole range of issues with the decision and the Secretary of State or the LPA, in this case, the Secretary of State, has conceded on, say, half of one ground. The main guidance on this actually arrives is in Dawes. That's not a pure planning case, it's a DCO case, and that concerned the redetermination of the Manston Airport DCO. So DCO had been made, that had been quashed. There were then various rounds of reconsultation, 2 or 3 distinct stages where the Secretary of State was receiving representations, sending letters out saying, have you got any comments on these representations, inviting further representations at distinct stages. But what did happen is pretty late in the consultation stage, a new report was introduced by the IBA, off the top, International Bureau of Aviation. This was all about need, so it was quite important. The Secretary of State then sent out a further letter asking for everyone, interested parties for consultation on specific points, and didn't raise the IBA point. So the particular claimant in this case, Dawes, didn't make any reps on the IBA report. Secretary of State remade the DCO, and the claimant challenged based on procedural unfairness. There's a lot wrapped up in this case, but the main thing that is interesting for our purposes is the claimant said, you didn't give me an opportunity to make comments on the IBA report. Here's a whole load of things where I think their views of what's necessary of the need case underlying the airport is wrong. And the Secretary of State and the interested party said, okay, the Secretary of State didn't invite representations, but there's nothing in the procedural rules to prevent the claimant making reps about that report. So this isn't the planning procedural rules, it's the DCO equivalent, but it's in very similar terms in that the Secretary of State gives an indication of what matters he wants reps on, and then gives an opportunity to make representations on those matters. So there's real parallels with the planning regime. DoveJ accepted the Secretary of State's argument. He said very clear, there's nothing in the rules to prevent someone making representations about matters that are outside the representations on which the Secretary of State has invited comments. Also of relevance in this case, and may or may not be relevant in sort of other planning determination cases, the various letters from the Secretary of State that went out at the various stages in the process made clear that representations were being received outside of the stages that he was inviting it. So again, DoveJ relied on that, saying basically it was pretty clear he was receiving a whole slew of things, and if you wanted to comment, you should have done. Although not in the planning context, I think that's a really interesting case. As to where that leaves us, I imagine DLUC are probably not thrilled at this concession by the Secretary of State, because it can rather indicate that their attempt to narrow the issues on which they want new reps might not be as successful as they would like, but we'll have to see how that plays out in practice. In terms of whether to open the inquiry, it's well settled case law that this is a pure matter of ordinary planning and rationality judgment. There's some guidance in the Hammerson case that if there's disputed issues of fact that need to be redetermined, or disputed new evidence, or new potentially determinative issues arise, then a new inquiry may be appropriate. But the simple fact that there might be new issues which could arise in the general claimant coming to court, well, you're reopening it, loads of people have things to say, something might come up, that's not going to be enough to justify it. It's unlikely to require reopening. Some examples of reopening, you may recall the East Quayside 2 case. This is the 239 homes up in Newcastle that was quashed on the basis of failing to, for heritage reasons, basically. The Secretary of State took the view that that had infected the entire decision-making process, so it's basically been opened. New inquiry, new inspector, de novo. For those who are following the Berkeley Homes case, the 165 homes in Cranbrook, Kent, Secretary of State has sent out his letter inviting representations. Don't know what he's going to do yet. That's just the stage that it's at. And as to the relevance of the first inquiry, if it's reopened, the IKEA Properties case from 2005 makes very clear that when a new inquiry is set up, it's an reopening of the original inquiry. So it's not second and distinct, which means the FSS, the first Secretary of State, whichever incarnation you're looking at, can't ignore the evidence received at the initial stages. But you do then get into a discussion as to how much does that Secretary of State on the redetermination need to actually refer to the previous decision or the previous inspector's report at the very least. And basically, this is a standard application of South Bucks reasons. So there's no obligation to specifically refer to the first report unless failing to do so shows that an issue's not been dealt with or not been dealt with properly. For those who operate in the space, I'm sure a lot of you wonder, does it make a difference? Certainly for clients, you explain that you go through all the stress of judicial review and it's just going to go back to the same Secretary of State or the local planning authority, and they say, well, what's the point? Does it make a difference? And actually, there's some really interesting research being done by Alistair Mills. He's an associate tenant of Landmark, but he's also a Cambridge academic. And he's been looking at this. And at the moment, it's a work in progress, but it looks like 2/3 of redeterminations following a judgment against the Secretary of State lead to a different result for the claimant. So interesting, watch this space. I'm sure that paper, when it comes out, will be widely quoted and widely looked at, but just to give you an indication of roughly where we are. Does it make a difference? The answer is yes.
Nick, we've got a couple of minutes left over, and one question's come up a lot of times in the chat. This is about when you have an interested party who isn't really interested and doesn't sign up to the consent order. Hasn't taken part in any of the summary grounds, hasn't played any part in any of the later stages, but just simply won't sign up.
Yeah.
Consent order. I think the recurring question is, what then? What do you do there?
Two options. You can try and say, well, if they don't want to take any part and they're not taking any part, then they're not really a party to the litigation. So treat it as a consent order. A bit iffy, but possible. In my experience, the easiest thing to do is write to the court, explain the situation, say the IP is taking no part. Here's the consent order we would be making and the reasons we would be making it on. Can you go ahead and just make a judgment in the ordinary way and do it that way? May or may not need a hearing. Sometimes, in my experience, the court tends to do it on written reps if there's really no concern or controversy. So that's probably the easiest way around and safest, because you then don't get into concerns about who's a party, who's not a party, which is very interesting for lawyers, but probably less helpful for people that are wanting a practical outcome.
Okay, well, thank you very much. Thanks.
Good morning. I'm going to talk to you about NHS contributions and the recent case of Mr. Justice Holgate from February of this year. So the context for this is that the issue of contributions towards healthcare has been rumbling along in the background of planning applications, planning inquiries, but there hasn't been a High Court decision on this previously. And this knotty problem met Mr. Justice Holgate, and what has arisen is potentially quite an interesting approach through a very complicated subject matter. So my talk is going to be predominantly about just one case, but I'm going to try and set the context for what's happened, why it's happened, what might happen next, and the extent to which this resolves something that's been a fairly significant issue in the background of some major schemes for several years. So the context for the University Hospitals of Leicester case was that Harborough District Council were the recipient of a request for a very significant contribution, around £1 million, towards healthcare in the context of a very major redevelopment project, an urban extension with 2,750 dwellings, and they, having gone through quite a protracted process involving getting advice from specialist KC, not me on the planning side, and alongside David Locke, who is now an associate member of these chambers, but a specialist in NHS funding. So they decided effectively to take a stand, and to not accept the contribution met the test, and they granted planning permission for the urban extension without the Section 106 contribution. Now, the context for the decision was that the claim for the contribution from the NHS Trust related to what was said to be a funding gap, due to the fact that it was said that the funding formula by which the NHS Trust secured their money was based on population registered to GPs. And so the premise of the claim was that there was a funding gap because there was a lag in the time in which new residents would come to be registered with GPs, and because the funding was always in arrears, there was, in a sense, a gap in the funding in their first year of occupation, and this would have all sorts of adverse impacts on the delivery of healthcare, and therefore it was necessary for that to be found out of Section 106 contributions. And so the judicial review was a challenge to the LPA's decision to grant planning permission without securing that contribution. And as I've sort of indicated, this has been an issue that's been rumbling on. There had been a catalogue of inspectors' decisions, almost all of them effectively approving the contributions of a similar type to this one, some of which had tried to wrestle with the underlying issues, none of which had produced authoritative rulings. There had been one case that had travelled to the High Court, but it had basically been resolved on a compromise basis, and it didn't produce any relevant guidance. So we now have the decision of Mr. Justice Holgate, which does give us some relevant guidance. At the beginning, I just want to clarify what it does and what it doesn't address. So I think it's very important for the talk that follows to keep in mind that this has no relevance to a claim for a contribution where actually it's possible to identify some, what I call, capital shortfall. So where actually what's being said, for example, is we need to provide a GP surgery, or we need to actually identify some specific item of other healthcare infrastructure where there's a reasonable relationship between the need for that and the development. This case is not concerned with that kind of specific infrastructure claim. It's concerned with this concept of what might be called a revenue shortfall contribution. So in terms of the legal context, it's relatively straightforward. I mentioned the development plan because actually for big schemes, there's almost always an underpinning in the development plan. There certainly was in the case of this development. It had a specific policy supporting it in the development plan, and there had been a discussion of relevant contributions in that development plan process. And there were actually healthcare contributions in this development plan, such as contributions towards GP surgeries, which were the type of the very specific infrastructure contribution, that capital contribution that was specifically identified, tested through the plan process. And it was striking that this contribution, the one at issue, the revenue contribution, hadn't been ventilated at all in that plan process. So the legal context was the development plan, obviously section 106, obviously regulation 122 of the SIL guidance, the familiar 3 limbs of that test. And there's a discussion about, if you like, whose responsibility that is, how does that relate to the case law. I'm going to come to bits of that. But also looming in the background, with the assistance of David Locke's submissions on this, was the question of the NHS funding regime. Mr. Justice Holgate analysed what I think it's fair to say was a pretty bewildering, complicated blend of legislation, regulations and guidance, all of which was quite opaque and some of which was quite contradictory. And Mr. Justice Holgate does give us quite a good steer through the complexity of that funding regime in his judgment. So absolutely critical to the whole case was the premise that there was a funding gap. And in argument at quite an early stage, Mr. Justice Holgate had teased out of counsel, leading counsel for the trust, a concession that if the trust couldn't point to a funding gap for the provision of health services attributable to the occupation of housing on the site, there was no relevant impacts from the proposed development to justify the contribution. So the central focus of the pleadings and of the oral argument was to see if the trust could make good the premise of their contribution, which was this revenue funding gap. To cut to the chase, Mr. Justice Holgate was not satisfied that the funding gap had been established. Now, how did he reach this point? Well, he undertook his careful analysis of the funding framework and concluded that they hadn't established it. So now their argument relied on the simple proposition that there was this funding gap because the funding formula worked in arrears, and so you were always running to catch up, and you had this irrecoverable deficit because you only took account of population on a looking back basis rather than a forward-looking basis. And as part of his analysis of the statutory scheme, Mr. Justice Holgate exploded that proposition, and what he found was, when you looked at the funding regime, there are basically 2 layers of funding. So there is a top layer, and there's 2 lots of terminology. There's what's called CCGs, clinical commissioning groups, which are now replaced under the new scheme that's applicable, with something with the same function, but basically called integrated care boards. So they get their funding directly, and then from them, the trusts seek the contributions and funding on the second layer. And the proposition was that the CCGs aren't funded for new residents, therefore the trust won't get anything to take account of population growth. And therefore there was this, because it was based on GP population, and therefore there was this, what, if you like, 1 year or short-term unbridgeable funding lag, because the only way you take account of population is by reference to GP registrations in the past year. But this, in fact, wasn't the case when properly analysed, because actually Mr. Justice Holgate identified that the proposition that there was no allowance for population growth in the first layer of funding was not accepted, because actually when you looked at it, there was an element of statistical based forward reflection for population growth built into the top layer funding formula. And secondly, as a matter of analysis of the rules and the guidance, in particular the terms of the national tariff, Mr. Justice Holgate found that it wasn't accepted that the trust was precluded from from having population growth taken into account in the formula that it secured from ICBs. So in a sense, he found that there was no exclusion of population growth in either level of the two layers of the NHS funding regime. And the critical point there is from paragraph 73, that having carefully analysed the scheme, he said the trust was not precluded from receiving funding from the CCG, now the ICB, effectively the top layer of the funding, which took account of projected population growth. And so, in a sense, the problem was that the trust was effectively operating on an asserted basis that wasn't consistent with actually the way the funding rules were written as Mr. Justice Holgate analysed them. And he was quite critical of the trust of effectively asserting in quite an opaque way that there was this funding grab, but failing to demonstrate that it was so when it was challenged by Harborough in their analysis and also when it was advanced in the submissions in the courts. So the implications of that point I'm going to come to, but Mr. Justice Holgate's judgment is useful because he also tried to tease out of the trust what precisely the legal basis of their case was in arguing that there was it was appropriate to seek a contribution in this case, and that brought him to consider the potential relevance of alternative sources of funding for a putative Section 106 contribution, because at one part of its argument, the trust was saying that the way that it was funded was an immaterial consideration. And Mr. Justice Holgate thought that was a stark proposition, which had potentially very wide-ranging ramifications for the development control system. And he teased out of the trust the sort of possible basis for this, which they had rehearsed in correspondence rather than so much in their primary legal arguments. And the only potential basis for this, in other words, the proposition that any alternative sources of funding is immaterial, was said to be there was some support was said to be derived from this from the speech of Lord Hoffman in the very well-known Tesco case, which is the first Tesco case, which is the one that says weight is a matter for the decision maker, and there's a seminal part of Lord Hoffman's speech that says that nothing is more essential than that weight is a matter for the planning decision maker. But actually, in the context of that case, which was about 106 contributions, that there was a historic analysis from Lord Hoffman of different provisions, and in the course of that, he had observed that market forces are distorted if developments are not required to bear their own external costs. And so in correspondence, the trust had effectively asserted that there was a general proposition that developments are required to bear their own external costs. And this supported the proposition that external costs, the alternate funding sources, etc., was an immaterial consideration. And Mr. Justice Holgate emphatically rejected that proposition, which, to be fair, he had to drag the proposition out of the Trust Council to then emphatically reject it. But that's very much what he did. And what he said in this judgment is then potentially quite useful and quite significant, because he said that part of the speech of Lord Hoffman was simply a contextual explanation of legal developments. He noted that Lord Hoffman, in fact, was not part of the majority speech in Tesco. It was a supporting judgment, and so therefore it didn't actually carry the support of the House of Lords in that case. He noted that that passage hadn't been relied on as a dicta in any subsequent cases as giving rise to a general rule as was alleged. And he also noted in any event, Tesco was at a time prior, in fact, to the formulation of the 3 tests, even in policy, but now we have the statutory instrument Reg 122 of the SIL regulations, and therefore it would be a matter for the planning authorities to always consider those. And so the position had therefore materially moved on in any event from the context in which, even if it was a proposition, that that dicta was expressed. So he was very emphatic about rejecting that as a possible basis for the decision. So that I think is potentially quite useful and quite important. But he also then put down a marker for what the position was in the future if local planning authorities are faced with a funding gap. So he, as I've said, his reasoning was the funding gap isn't established, but he set some quite significant hurdles in the way of these contributions, even if the funding gap were to be established. So he makes 3 points that are potentially very useful in the future. So firstly, it would be a matter for the local planning authority to consider whether it would be appropriate to require a financial contribution to be made after taking account of other requirements and the impact on viability. So even if there is a funding gap, effectively there would be a planning judgment about the extent to which it was reasonable in all the circumstances for this to be met as a Section 106 contribution, taking account of the range of other requirements and also the impact on the deliverability and viability of the scheme. Secondly, he left open the possibility that if actually it could be established that there was some kind of systemic problem, so in other words, that you at stage 1 you got the funding based on projected population growth, but at stage 2 it wasn't actually efficiently distributed to where that growth was coming, then he said that that was an issue which actually because the local planning authority in this case had been part of their rationale for not imposing the contribution, that was challenged in these proceedings, but actually Mr. Justice Holgate thought that was actually quite a perceptive contribution to the understanding of this area. And so if actually you could show, okay, there is a funding shortfall, but the reason for that funding shortfall is actually really due to deficiencies in your funding system, then that is relevant to how reasonable it is to seek that from developers by way of a Section 106 contribution. And then thirdly, he said that actually the discussion of how population growth had in fact been projected in the level 1 and primarily in the level 1 funding of the 2-stage funding. In other words, if there was some difference of approach in what was cooked into the forward-looking indicators as to how CCG and ICBs were funded, that was something the court might need to wrestle with in the future before holding that the contribution actually met the SIL tests. So there's a list of, if you like, future hurdles which would face any NHS trust that actually got past the position that this trust got to and did manage to establish that there was actually some kind of revenue funding gap. Well, they still had 3 future hurdles laid out for them in Mr. Justice Holgate's reasoning. So that's the judgment. There was then a sequel, which is a bit of a non-event really, because there was a future challenge that didn't get past the permission stage, and actually most of that judgment was dealing with disclosure issues that aren't particularly relevant for present purposes, but there was an attempt effectively to re-argue the same points on slightly different facts and it came before the same immovable force, Mr. Justice Holgate, who refused permission to proceed. And I don't think there's anything in his reasoning in the sequel case of Worcestershire, which is only a permission judgment, that changes anything. It's really an application of the basic logic of you haven't established your funding gap and therefore your claim doesn't get off the ground. So does this long-awaited and comprehensive judgment solve everything? And I think the answer to that is not sure. Watch this space, because notwithstanding the difficulties in terms of the analysis of the funding framework and the future obstacles, it's my understanding that NHS trust bodies are still seeking pretty much equivalent contributions in other cases, and saying, well, that was a fact-specific judgment and these facts are different for these reasons, and so therefore we're seeking this contribution. So the issue still appears to be bubbling away at the stage of applications and potentially appeals. However, it seems to me that what Mr. Justice Holgate's judgment does do is it provides a very useful, rigorous analysis of the funding regime. It provides a series of hurdles that would be established, would need to be crossed even if a funding gap was established, and it shows, at least on the facts of that case, how the funding gap wasn't established when one analyses the funding rules. So my view is that it has become much more difficult for the type of contribution to succeed. But as I say, this doesn't deal with capital issues. It only deals with this type of revenue funding. The other thing I'd like to just make clear is that the whole premise of the argument in this case, and the whole basis on which the local planning authority made its decision, was to accept that it might be possible to have a Section 106 contribution that was purely for revenue funding. In other words, not to take a sharp distinction between capital funding and revenue funding, but to argue that on these facts it hasn't been established for all the reasons that I've gone through. So I think it would be going too far to say that this case rules out any type of revenue contribution. What I think it does is it invites a rigorous analysis of whether any funding gap actually exists, at least in this context, and possibly transferable to other contexts. And then it also, I think, paves a framework for planning authorities to treat themselves as having responsibility for answering the SIL Reg 122 tests, and also gives a clue as to how they might answer those in terms of weighing up overall contributions and priorities. So I hope that's a helpful journey through the contributions case, and I will hand on to Jenny. Thank you very much.
Thanks very much, Dan. Good morning, everyone. I'm going to be talking about the annual roundup of Planning Act 2008 legal challenges, which is challenges to DCOs and about DCOs. I've got a, hang on, let me just get my, am I on? Yeah, there we are. So my talk is a story of 10 cases. You'll be happy to hear I'm not going to go through each in detail, and I just simply don't have time, but those are the 10 cases that are either challenges to DCOs or are about DCOs from the last year. So they're chronologically listed from December last year right up to last week, the bottom one. And the references are there for your assistance to find them. So breakdown of them. I've had a quick look through of themes. 7 out of the 10 are judicial reviews of DCOs that were granted. All those 7 judicial review claims were dismissed. There was one JR of a decision to refuse a DCO, and that was granted. So the decision to refuse was quashed. 2 of the 10 were applications for declarations about things like jurisdictional issues, which I'll come on to. Those declarations applications were refused. I've then given you a quick breakdown of the court and judges. So there's one Court of Appeal case, and you can see the others there, 2 from Mr. Justice Holgate, 2 from Mrs. Justice Thornton, and then Lang, Dove, Leven, Lane and Chamberlain all have a look in. Of the 10, 6 were energy cases, 2 were for road schemes and 2 were for airports. There was also another road scheme case that I was involved in for National Highways, which was refused permission at the permission stage, so that's not included. That was the A428 Black Cat roundabout case, in case you're familiar with that area. And then of the energy cases, of the 6 energy cases, 2 were about wind, 1 was solar, 1 was tidal, 1 was an interconnector between the UK and France, and 1 was nuclear. But all those electricity generation cases were largely about the need for substations, electricity substations, rather than the actual wind or solar development themselves. And then the themes and issues that were raised, well, I mean, actually, on reflection, those 10 cases cover just about every single theme and issue that is raised in the planning court. So every theme or issue of public law relating to planning. So there's consultation, procedural fairness, consideration of alternatives, carbon and climate change, EIA, habitats, also flood risk, also heritage, just about every single issue, perhaps apart from, no, Greenbelt was there too. So if you want a masterclass of planning issues in the planning court, read those 10 cases. So I'm going to attempt to give you a quick overview of the 10. Starting with Sizewell. This was the JR of a development consent order for the Sizewell C nuclear power station. The case was really rooted in the fact that the nuclear power station required a potable water supply, and that water supply was not identified at the stage of the application for the DCO. And a lot of the grounds of challenge related to that. So there were habitats regulations grounds concerning the definition of the project, i.e. should the project include not just the nuclear power station, but also the water supply? And so should the cumulative environmental impact of the power station and the water supply have been considered? Natural England had advised that it should be, and Natural England also advised that the consideration of alternative solutions should be considered. And there was challenge to the conclusions on IROPI, i.e. imperative reasons of public interest, of overriding public interest. There were grounds relating to greenhouse gas emissions and whether the power station would really contribute to the long-term reduction in those emissions. I think it was about 78% reduction across the country, and whether that was properly supported by evidence. Challenges to rationality and reasons relating to whether the site would actually be clear of nuclear material by 2140. Error of law alleged about the greenhouse gas emissions of the construction. So many varying grounds, many were relating to irrationality and reasons. All grounds were dismissed. It was a matter of evaluative judgment as to whether a cumulative assessment was necessary. It was considered that the 2 aspects, i.e. the power station and the water supply, were separate projects, and there would be no gap in assessment because the cumulative assessment would happen at the stage of the statutory process for the water resources management plan that would come later. Adequate reasons were given for not taking on board Natural England's advice, and that was described anyway as just assertions rather than reasoned advice, and it could not be said that any part of the decision was irrational. So quite a full decision covering a lot of topics there. The next decision, Bristol Airport. This is already covered, has already been covered and will be covered, I know, by Siân, so I'm not going to go into any detail on this. Many of the grounds related to climate change and carbon, and Siân will be dealing with those. There was a ground also about habitats and whether the requirement for a replacement habitat, whether that was mitigation or compensation under the habitats regs, because if it's compensation, it requires the IROPI, so the justification of overriding public interest to allow the project to go ahead. The court held that there was no mistake by the panel as to it being mitigation rather than compensation, because the replacement habitat was going to happen in advance and would be there to avoid impact rather than compensate for impact. And in terms of MPPF paragraph 188, which is about assuming that other pollution regimes operate effectively, the court, and this was Mr. Justice Lane, the court considered that the Climate Change Act was a national emissions control regime for the purposes of 188, and so it was not irrational to rely on that. Next case, doors. Again, this has been touched on already by Nick, and I'm not going to go into it in any detail, but I've put the outline on the slide just for your reference. It was a decision of Mr. Justice Dove. Next case, Boswell. This is a case largely about climate change, and so I'm going to leave it for Siân to consider. But again, about the interaction this was between the EIA regs and consideration of climate change, and whether there should be a cumulative assessment, and the unique nature of climate change and climate emissions being global, not local, and so not fitting quite so easily with cumulative assessment under the EIA regime. Also noteworthy that challenge was fully dismissed, but permission to appeal has been granted to the Court of Appeal, and there's another case behind that, which I'll come on to. Next one, this was a challenge to a refusal of a DCO, a decision of Mrs. Justice Leven. The refusal to grant the DCO was contrary to a recommendation of the examining authority, and the Secretary of State's view was that the developer had failed properly to consider alternative solutions for the substation, so for the electricity substation at the end of the interconnector from France to the UK. The Secretary of State's view that alternative substation may cause less environmental harm, and that should have been considered more fully. What had happened was the developer proposed using the Lovedene substation as opposed to the Mannington one, because the Mannington one was intended for a wind farm, so was not available. However, during the course of the examination, it transpired that the wind farm had been refused permission, and so the Mannington had become a potential possibility to be used. But there was a report from National Grid saying that Mannington was still not appropriate to be used for this project for other reasons. Secretary of State had failed to take into account that relevant evidence from National Grid, according to Mrs. Justice Leven. He'd also failed to apply the national policy statement, which was specific to this type of development, which said that when you're considering alternatives, you have to consider whether it's realistic prospect that that alternative might deliver the same energy capacity in the same timescale. And the Secretary of State had failed to apply that rigorously, or failed to apply it at all, when suggesting that the developer should have considered that alternative. And the Secretary of State had failed to make further inquiries as to the feasibility of Mannington, and so had acted irrationally and in breach of his Thameside duty, which that's quite an unusual finding. It's quite a high test to establish that a decision maker has acted irrationally and failed to make further inquiries. So it's quite a useful case if you're trying to allege that, to see where it can be, can succeed, a claim like that can succeed. That's the first case on alternatives. Two other cases on alternatives. One, a judgment of Mrs. Justice Lang. Now, these followed the high watermark for consideration of alternatives, which was established by Mr. Justice Holgate a couple of years ago in the Save Stonehenge case. If you remember in that case, obviously it was a pretty exceptional case. It was a tunnel next to Stonehenge. But in that case, Mr. Justice Holgate established that in the NPS, the paragraph 4.27, which says that the Secretary of State only has to review National Highways consideration of its optioneering process and check that it's been done, rather than has to actually consider the alternatives for himself. That paragraph 4.27 does not override the preceding paragraph in the NPS, which is paragraph 4.26, which requires the consideration of alternatives where other provisions require it. So, for example, EIA, habitats, or where there are particular policy provisions requiring it, or where case law requires consideration of alternatives. That's the sort of background. That's the Save Stonehenge background to all of this. That's been leapt on in a number of subsequent cases, including this one, which was another case about an onshore substation, in this case in relation to wind farms, offshore wind farms. And the alternatives aspect of this was firmly rejected by Mrs. Justice Lang. She said, having reviewed Save Stonehenge, which in turn had reviewed all the case law on alternatives, that there's no principle of law that the consideration of alternatives is a mandatory material consideration and is mandatorily required in every case where the existence of a need is relied on to outweigh adverse effects. Alternative sites do not become a mandatory material consideration in those cases. They're only relevant still in exceptional circumstances, as in Save Stonehenge. So that's the alternative aspects of this. Other issues in substation action was flood risk sequential test. Mrs. Justice Lang held that there is no requirement to apply a sequential test to surface water flooding. So you don't need to find that this is the only site with that there aren't sequentially preferable sites with less surface water flooding, and it's a matter of planning judgment exactly how to apply a sequential test for flood risk. Other issue was heritage. The duty to have regard to the desirability of preserving listed buildings under the DCO regime, i.e. Regulation 3 of the decision regulations, is different from the similar duty under the Planning Act, i.e. Section 66(1) of the Listed Building Act, which is a requirement to have special regard to the desirability of preserving listed buildings. That latter duty, as we know from a series of case law, does require a certain degree of weight, or that considerable importance and weight have to be accorded to listed building preservation. That higher duty, or that enhanced weighting, is not present in the DCO regime, because there it's only a duty to take into account the heritage issue, i.e. to have regard, not to have special regard. Next case, this is a very recent case, hot off the press, a case I was involved in, which the judgment was published on Friday. It's another highways case. Ground 1 is all about climate change. That was stayed pending the outcome of the Court of Appeal in Boswell. But Ground 2 was all about the consideration of alternatives. It was a Greenbelt case. The claimant had said that in all Greenbelt cases, there was a mandatory duty to consider alternatives because of the very special circumstances requirement. That was comprehensively rejected, and the claimant did actually draw back a bit from pushing it. The primary argument was that the DCO had been promoted itself and determined on the basis that there was a lack of alternatives that would do less harm to the Greenbelt. That was because of that, the claimant said, well, the Secretary of State needed to consider those alternatives for himself. That was comprehensively rejected as unarguable, in that the DCO had not been promoted on that basis. It had only been promoted on the basis that there were no alternative non-Greenbelt sites, not that there were no alternative sites that might have less harm to the Greenbelt. So there was no, so the way it was promoted and the way it was determined did not bring in the consideration of alternatives as a mandatory consideration for the Secretary of State to get personally involved in. The secondary argument that the claimant brought was that in that case, because of what was proposed, which was a highway scheme through the Greenbelt that was permanent and irreversible, and that was on a similar site to the alternatives, because of that, there was an argument that this was a mandatory material consideration. Again, that was comprehensively rejected. It was granted permission as arguable, but comprehensively rejected by the court. The factors for alternatives being a mandatory material consideration as opposed to a potential material consideration that the decision maker is able to take into account, those factors were not present, and there was no error of law in the decision, and the decision for the DCO was upheld. Next was a procedural type case. This was an unusual case where the claimants were arguing that their complaints as to agreements that had been made between the developers and the landowners, that had stifled the landowners from presenting objections to and information about the scheme to the examination. Those complaints had been rejected by the Secretary of State in granting the DCO, and the complaint was to the court was that was unfair and procedurally wrong and had a chilling effect. What had happened was landowners had signed heads of terms regarding their CPO interests, so their interests that would be granted compulsory purchase over by the DCO. And as part of those heads of terms, they'd agreed not to oppose the DCO and to withdraw any objections that had already been made. The claimant said, well, that had a chilling effect on what was going on. And Mr. Justice Holgate was like, well, what do you mean by that? Chilling effect is not really an applicable principle or an applicable concept to this type of situation. Chilling effect really applies to where people's rights are impacted and where people feel inhibited from expressing their opinions and have their rights compromised by something that causes that effect. Here, there was no complaint of unfairness because none of the landowners themselves were suggesting that their rights had been impacted. And the way that the case had been morphed was really to say, well, this had an effect on the quality of information that came forward from the landowners. And that was really what it was all about. There was no real allegation of unfairness. In those circumstances, the way those complaints had been rejected by the Secretary of State was rational and fair, and the Secretary of State had been acted completely appropriately in not investigating the complaints any further. So an interesting case, but quite firmly rejected. This next case is really about an application for declarations rather than a challenge to the DCO itself. It arose as part of a Section 78 inquiry into a solar farm. The local planning authorities had refused the applications, but then said, well, actually, they're not even Section 78 type applications at all. They are NSIPs, National Significant Infrastructure Projects, because they are extensions to an existing solar farm and bring it above the relevant threshold of 50 megawatts capacity. This inspector thought she didn't have jurisdiction to deal with this issue, so adjourned the inquiry for a judicial review to take place, and the planning authorities brought a judicial review seeking declarations that they were NSIPs. The defendants, there was some discussion about whether the court had jurisdiction at all to determine whether or not they were NSIPs, as this was a matter of evaluative planning judgment for the Secretary of State, and the Secretary of State was usually the person charged directly under the Act to decide whether something was an NSIP or not. The court said, no, we have jurisdiction in other aspects of this, which involve deciding whether or not something is an NSIP, for example, as to whether to grant an injunction, an enforcement injunction. That involves that sort of judgment. The court is well able to make that evaluative judgment in certain circumstances. On the particular facts, the court decided it was not an NSIP because the other equipment stuff, like the transmission pipeline, the distribution cabling, the apparatus, none of that was part of the generating station. And partly because of that, it didn't join the future solar farm with the existing consented solar farm. There were two different projects and it was not an extension. And it's quite a useful case which considers the various factors at issue as to whether or not something is an extension to an existing project. One other obiter point, which is very interesting, was that the court said, just because, even if it were an NSIP, that would not oust the jurisdiction to grant planning permission or not under the 1990 Act. You might need both, or you might need just the NSIP permission consent, but that doesn't mean that the decision maker under the 1990 Act cannot grant planning permission for it. Last one, I think, let me just check. Yeah, last one. Very quickly, This is the Court of Appeal case, and it involved whether a provision in the DCO itself applied to modify or exclude the statutory provision. Now, under the 2008 Act, there is a specific provision which enables a DCO to amend the statutory provision as to the prescribed period. And this was important because the statutory provision was that the development must begin before the end of the 5 years. The DCO requirement was that development must commence no later than the expiration of 5 years. The definition of commence in DCO was different and more generous than the less generous than the definition of begun. It was, the question was, did that commence requirement displace the begun requirement? The court said on the interpretation it did. And because the development hadn't commenced in time, the developer couldn't rely on the fact that it had begun in time in accordance with the statutory requirement. And as a result, the DCO had lapsed, and the Court of Appeal affirmed the decision of Judge Jarman QC in relation to that. So it's a very interesting point about statutory interpretation, how a DCO may amend the statutory requirements, and also the fact that you can't bring in an additional requirement in relation to commencement. If you're going to bring in a commencement requirement, that will amend the begin requirement in the Act itself. Quite a technical small point, but quite an interesting point of public law. And I know I've had to race through and I'm being asked to end. So now we'll go to the panel. Thank you very much. Sorry, not the panel, to Siân on climate change and legal challenges. Thank you very much.
Thank you very much, Jenny, and hopefully you can all now see and hear me. And I'm just checking. I've got control of the slides. Brilliant. So this is going to be a very whistle-stop tour. As many of you will know already, there's been a lot happening in this area of climate change-related legal challenges. So this is just going to be a snapshot of the most significant cases from the last 12 months, some thoughts about the overarching themes that emerge from those, and in general, what we can take in terms of a general direction of travel. And I'll finish with a couple of points to look out for over the coming year. And I think all the cases that I'm going to mention today have already been discussed by my much more learned colleagues this morning, which really illustrates the overarching point that no case is ever really, in the UK, certainly about climate change alone. And I'll just be revisiting those cases that they've already discussed and highlighting the more climate change specific dimensions. The first point to note is that we're going to look at 5 specific cases, and as things stand, none of those in the planning context has been successful as a challenge. So first up, we have Finch, which you'll all already be aware of and has already been covered this morning. Now we're waiting for the Supreme Court judgment, but as matters stand, it was unsuccessful both in the High Court and in the Court of Appeal, albeit with a dissent, which we're going to look at. Then we have the West Cumbria Mining Limited case, which raises similar issues. We don't have a judgment on that yet, but noting that it was refused permission before a rolled up hearing was ordered. Then we have 2 airport expansion cases, both of which have come up already, the Bristol Airport case and the Manston Airport case. Those were both unsuccessful challenges, and which were based to a large extent on climate obligations, which we're going to look at. And then a highways case, which Jenny's already mentioned in a bit of detail, which was also unsuccessful. But a lot of those, well, several of those are waiting for appeal decisions at the moment. And as we'll see, we've got more cases coming up. In particular, we'll expect litigation in the context of the EIA 2023. And then we'll look at some challenges which have been brought at a slightly higher policy level by Client Earth and also cases outside the immediate context of planning law that will no doubt in time start to bleed into and have implications for planning law more specifically. So the first case in our whistle-stop tour has to be Finch. And this at this present stage is a judgment from the Court of Appeal. We're awaiting the outcome for the Supreme Court. But it's worth a mention here because it was heard in June, and the judgment, when it is handed down, will obviously be very significant. I think the main thing to highlight in terms of climate change is the disagreement between the High Court and even within the Court of Appeal. So Holgate, who gave the judgment in the High Court, had held that, dismissed the application for judicial review and held that emissions from future combustion of the refined oil products from the proposed development were, quote, as a matter of law, incapable of falling within the scope of the requisite environmental impact assessment. He also held that the true legal test of whether the effect constitutes an indirect, likely significant effect of the development is, quote, whether the effect on the environment is an effect of the development for which planning permission is sought. Now, the Court of Appeal took a slightly different approach, and they agreed, the three members of the panel agreed on the principle, which was essentially that consideration needs to be given to the degree of connection between the development and its putative effects. So in principle, they disagreed with Holgate that emissions from future combustion of refined oil were, as a matter of law, capable of falling within the scope of an EIA. So they disagreed with Holgate on that, and they found instead that this question of whether these, what were referred to as scope 3 emissions, needed to be assessed was one of fact and one of evaluative judgment for the planning authority. But they then disagreed as to how that principle should be applied to the facts of this particular case. So you had the president handing down judgment held that the decision to exclude those emissions from the EIA was lawful on the facts of this particular case, and that was a decision with which Lord Justice Lewison agreed. But then a dissenting judgment from Lord Justice Moylan applying the same principles, but finding on his analysis of the application of those principles that the council's decision had been unlawful, and in the circumstances the EIA should have included an assessment of the downstream emissions and the inevitable impact of that project, which involved extraction for commercial purposes. So this, of course, has gone up to the Supreme Court, and you might think that the disagreement between the High Court and within the Court of Appeal demonstrates the difficulty that decision makers are going to have in applying these principles in practice unless the Supreme Court draws quite a clear-cut approach, and we'll have to wait and see whether they manage to do that. So we're expecting that, and stayed behind it is the second case, Friends of the Earth versus Secretary of State for Levelling Up Housing and Communities. Now, this was listed as a 3-day rolled up hearing in October 2023, but has been stayed because we're waiting for the judgment in Finch, which I just referred to. Now, one of the key issues in this case is the exact issue, which we are hoping to get an answer to from the Supreme Court. But there are other wider issues beyond Finch. Perhaps the most significant of those is the argument in relation to carbon offsetting. So the argument in this Friends of the Earth challenge is essentially as to whether the Secretary of State can, or Friends of the Earth say cannot, consider international projects to support a finding that a project is net zero for the purposes of the national regulatory regime. And obviously that will have significant consequences if the High Court determines that. That might well be one that goes further as well. And then there's also this slightly softer point where Friends of the Earth are arguing that the international impact in terms of the UK's claim to climate leadership and what they say is the damaging precedent that is set by the optics of the UK granting permission for a new coal mine in the first place. So we'll get to see what the High Court makes of that argument if the claim progresses once the judgment in Finch has been handed down. The next case, which has already been mentioned again, is the Bristol Airport action case. So this had a very clear and specific climate change dimension to it. And although it's already been discussed, this was is worth mentioning again in the specific context of climate change litigation. And to quote Mr. Justice Lane, the broad thrust of the claimant's case was that the airport's appeal should be dismissed because the expansion would have a serious and unacceptable effect on climate change. And again, quote, so far as climate change is concerned, the general question which underlies the claimant's grounds is whether and to what extent aviation emissions should play a role in deciding whether permission should be granted under the 1990 Act. Now, Alex has already explained that the court decided that non-CO2 emissions did not have to be considered, and that was because of the lack of scientific consensus as to how these should be dealt with. But Barn had also, BWAN, that is, had also argued that the panel erred in law by refusing to consider the impact on the local authorities' carbon budget. Justice Lane dismissed that argument and found that the impact of the proposal on the local carbon budget was only a consideration to which this decision maker may have regard if, in their judgment and discretion, they think it's right to do so. And here the panel was entitled to exercise its discretion in deciding to give that consideration essentially no weight. It hadn't acted irrationally in doing so, and the reason for that was that such budgets have no basis either in law or in policy. So pretty clear ruling from Mr. Justice Lane, perhaps diminishing what might have been thought to be the importance of local authority carbon budgets. The Action Network had also argued that the panel had erred in treating the Climate Change Act and the various duties which that placed on the Secretary of State as a separate pollution regime, and in arguing that there was an irrebuttable assumption in paragraph 188 of the NPPF that regime would operate effectively. Now, Mr. Justice Lane found that the panel's reasoning didn't depend on paragraph 188 of the NPPF, and in any event, there was no basis for contending that the panel had assumed that assumption was irrebuttable. So another unsuccessful challenge there, and you'll start to see a theme emerging here. We've already discussed doors. Just check you've got that slide up. Doors, and again, the doors has been covered. This was the Manston Airport reopening as a freight facility. And the key points that we take from this are consistent with the themes that we see emerging in these other challenges to specific planning decisions and infrastructure projects. First, public law decision makers can rely on their own unchallenged policies to deliver the outcome for which those policies were designed. So here the issue was around the Jet Zero policy. And the Secretary of State was found to be entitled to rely upon that to support his conclusion that he could expect an acceleration in decarbonisation in the aviation sector, and ensuring that carbon budgets were met without directly limiting aviation demand. And that was a sufficient answer to the challenge which had been brought on the basis that the minister had been given advice from the Climate Change Committee that there should be no net expansion of airport capacity unless it could be shown that the aviation industry was on a trajectory to outperform net emission targets, and that would enable additional demand to be accommodated. That was overcome by the Jet Zero strategy, and the Secretary of State was entitled to rely on that. The other key point which emerges from this, which again has already been covered, but is particularly relevant in the context of climate change related arguments, is that there's nothing to preclude expert evidence from being provided in decision-making or consultation process where some of the underlying data or evidence hasn't been disclosed and has been withheld on grounds of commercial confidentiality. That omission does not render the consultation process unlawful. It's a matter for the decision maker to decide what weight should be attached to the evidence in the particular circumstances. And a reminder from the court that there are high hurdles for finding that a consultation process was so unfair as to be unlawful, and for a finding of irrationality in terms of the judgment exercised by the public law decision maker in decision making around that consultation process. So we see how that applies where underlying data and evidence has been withheld during the process. Then we have a highways case, just similar principles, but in a slightly different context. Here, the claimant issued proceedings in the High Court, and the essence of the challenge was that a cumulative carbon impact assessment should have been undertaken in relation to each of 3 schemes, which had all been approved and assessed individually. So the claimant said that the impact of the schemes together should have been compared against national carbon budgets. And that was another unsuccessful challenge, although, as Jenny said, that's been granted permission to go to the Court of Appeal. So we wait to find out whether this will be overturned. But for now, the court has concluded that the question whether there should be a cumulative assessment, how that how any cumulative impact should be assessed, and whether those effects are likely to be significant, are all matters of evaluative judgment. So those are all questions for the decision maker, who may choose to assess the significance against the national target, but need not do so. And the fact that that hadn't been done in this case did not render the decision unlawful. And a reminder there from Thornton that the courts must be astute to be drawn into the arena of the forbidden merits. Decisions regarding, particularly regarding infrastructure projects and their effect on climate change, as a subject attracting many widely differing views, whether for or against. I think that's a theme throughout planning and public law, but particularly strongly in the context of climate change litigation, that the courts consistently reluctant and wary to be drawn into anything that might be regarded as the arena of the forbidden merits. Now, I'm conscious of the time and the need to hand over for a Q&A session, but just a couple of things to look out for coming up in the next year. Firstly, duties that have been added in the Levelling Up and Regeneration Act 2023. So whether this is progress or not, there'll be debate, no doubt, and there's been watered down from what would have been special regard for the need to mitigate and adapt to climate change, which was the amendment passed by the Lords, and now just regard, which is the language that has eventually made it into Section 94, but no doubt we'll see challenges arising from those new duties and the particular language which has eventually made it into the Act. More broadly, then there's kind of 5 unsuccessful planning challenges that we've seen here. At a slightly higher level, there has been success. So the addendum to the successful challenge, the net zero plan, which was brought by Friends of the Earth and Client Earth. That was the 2022 judgment. Which is on the slide, the government revised its net zero strategy, and the revised strategy now faces a fresh challenge, which was lodged in July of this year by the same 3 organisations. And that claim is based on a lack of detail as to the level of risk posed by each policy and an alleged breach of the Sustainable Development Duty. And then just it's worth keeping an eye on as well on what is going on beyond the planning context. So I've put in particular there the shareholder claim that was brought by Client Earth against Shell, which wasn't given permission to proceed, but you start to see climate change increasingly becoming an issue beyond the planning context and bleeding into all other areas of law, and that's as ever worth keeping an eye on, because no doubt as time goes on that will start to have increasing implications in an interaction with the planning context. And I think that has been a very whistle-stop tour, but those are the key highlights in terms of climate change. And I think I'm handing back to David for a Q&A. Thank you.
Thank you very much, Siân. Thank you, all the speakers there. Just to remind everyone that all those slides, I think there's 66 of them, will be being sent through by email immediately after this question and answer session finishes. So you'll have access to those. I'm going to now pick up on some of the questions that have been raised in the chat and also some that have been sent to me in advance. Jenny, can I just start with you? You mentioned the Sizewell case, which is obviously a pretty stark case on what is the ambit of the plan or project. I understand it's been heard in the Court of Appeal. Any hint as to when a judgment might be due on that one?
No, sorry, I just don't know.
Okay, and obviously you've been involved in quite a lot of cases in on both the DCOs and just normal challenges under Section 78 decisions under 288 and so on. What's the main difference in the approach of the courts? If you look at your list of successful challenges, it's a bit solitary warning to everyone not to take DCO or type challenges, really. I mean, what is it about the DCO world that makes challenging those decisions so much harder than Section 78 and 288?
Well, I'm not quite sure that's right, because in a sense, the last year has probably been quite unusual in the context of recent years, where there have been in the preceding few years there were some quite high profile successful DCO challenges like Save Stonehenge, like Pierce. So I mean, I don't think there's any real difference in principle. I mean, obviously these are big national infrastructure projects. There's perhaps a little bit more leeway given to the decision maker because of the wide range of objections, the wide range of matters to consider, that the kind of stringency of reasons required is perhaps not as high as it would be on a single planning application. So it's perhaps a bit more akin in that sense to a local plan challenge, because there's so much to consider. But also, I mean, the difference procedurally is a DCO is a judicial review, and that's prescribed by Section 113 of the 2008 Act. It's a judicial review rather than a statutory review, so it has different relief provisions as well. Like it's Section 1, the Act, the Senior Courts Act applies as well in relation to whether you get relief or not.
Okay. Thank you very much for that. Dan, there's been a lot of questions on the health contributions, and we all know that lots of local authorities have been granting them because it's either the amount of money at stake has not been enough to justify a row about it or whatever. What happens to all those historic contributions now?
Well, I think it's a very interesting question. I'm not aware of there being any sort of litigation or putative litigation in relation to that. the two thoughts that occur to me is whether there could be any kind of restitutionary claim on the basis of a payment made under a mistake of law. I think it would potentially be worth thinking about, but obviously restitution would raise questions about whether, for example, there had been a change of position, and if that money had been spent, I think that would be very difficult. If it hadn't yet been spent and hadn't yet been applied, then I would think that the first place to look would be the terms of the Section 106 itself, to see whether actually there's a specific clause requiring it to be applied for purposes, and if actually the judgment actually gives rise to the argument that it's incapable of being applied for those purposes, then there may be an easier contractual remedy to say, actually, we can't now spend this money because actually it was given for specific purposes that now we know actually can't be made. So I think it's fact specific. I think it would be very messy, but if it's a major contribution, it might be worth looking at. But I think there would be probably some significant obstacles if the money had already been spent.
And what happens if there's a 106 obligation where it hasn't actually been paid yet? Do developers simply not pay and say this was all on a false premise?
Well, the difficulty with that would be that there would be a contractual obligation to pay it. But I suppose if it was worth enough money, I suppose it could be worth seeking a declaration as to whether actually it's due, in the light of the fact that it would now be known to be a mistake of law to pay it. But I think that one might need to obtain a declaratory relief or something in that they're declaration that they're not required to pay it because it was secured under a mistake of law.
And I suppose a 106A application might be successful. The council would find it quite difficult to justify not amending a 106 if they knew that the logic for it had been undermined by Holgate's judgment.
That's interesting. And so, obviously within 5 years it would have to be by agreement, but actually you could force the issue as a developer by making the application. So again, I think that would be worth thinking about. But obviously, it would be worth thinking about. It would probably depend on the specifics of who's a party to it, who's entitled to enforce it as a matter of contract. Would their consent be required for the variation, etc., etc.? And those answers might be different on different facts.
There's one theme that's come through on the questions for local authorities in particular isn't this NHS issue just a symptom of a lack of joined up thinking between NHS planning and planning, in the sense of making sure there's adequate provision at the right time for the right needs as you get major new developments, and how should local authority officers go about squaring that circle?
Yes, I think it's a symptom of a whole series of things. The bewildering complexity of the funding system, the sort of engagement with it actually as a sort of rearguard action. And the other thing that strikes me is that actually the CCGs are consulted quite a lot in terms of strategic planning. And that's where you can actually throw up, is there any actual infrastructure, etc. But actually the people that, because of the two tiers, the trust were the ones that felt they were getting a hit. They weren't consulted in the plan process. So, I think the answer is definitely a great deal more joined up thinking. If you were a trust, I think you would want to get interested in what the structure plan has to say, but you may not be best pitching it in terms of the type of revenue contribution. You might be better in finding ways of saying, actually, we've got these identifiable infrastructure properly so-called contributions, and so we're not just pitching it at the gap. But I think that would probably be a more productive way of them engaging. And yes, I think it is a different case if they're making the identified infrastructure requests in the context of an emerging plan.
Thank you very much. Sean, can I just pick you up on a couple of things from yours? The Finch judgment, obviously it's going to be a crunch judgment in the whole of this arena, I guess.
Yeah.
Any idea when it's expected, and any gossip as to how it went?
No gossip. I think the fact that the case that was listed behind it, the Friends of the Earth one, was for, I think, towards the end of October 2023. Suggest perhaps we were expecting it sooner than we've got it, but so perhaps not too long to wait, but no gossip that I'm aware of.
And how do you see the 2023 Act, Urban Regeneration Act, playing out in terms of climate change? Has it got any relevance to this?
Yeah, certainly. I think you can expect to see that being introduced into these claims, probably as part of the mix rather than claims exclusively relying upon that. But it's had an interesting passage through Parliament in terms of a lot of debate about the distinction between regard and special regard. So it'll be interesting to see what the courts make of that particularly.
Yeah. Well, that brings me on to questions for Alex. Well, one question that seemed to be really interesting was we've got this flurry of cases on the EIA and SEA every year. We've done a talk like yours for the last, I don't know how many years. To what extent is that case still going to be of any help now for the future under EoRs?
Yeah, I thought that was an excellent question as well. I mean, in part, it depends on how similar the new regime is. Obviously, the more similar it is, the more you can draw on the old case law by analogy. But even if it's very different, similar issues, or at least vaguely similar issues, will need to be decided with no directly on point case law. So why wouldn't courts reach back to that mature body of environmental case law we already have to answer those questions? It might take a bit more in the way of sort of contortion or sort of jamming the old case law into the new regime, but it's a bit odd to think that they would start entirely from scratch. I just don't see it happening.
I'd like to start entirely from scratch, yeah. Now, one question that's cropped up from all perspectives, developer, local authorities and government departments on this chat, has been, what about the transition? I mean, how on earth do we get to these EoRs when we haven't got the guidance or the statutory instruments yet, or even the consultation on the guidance or the statutory instruments yet?
Yeah, another good question. So first point, please don't be alarmed, everyone. So the power to introduce EoRs comes into effect on Boxing Day, as someone pointed out, but that's just the power to make the regs. Nothing happens at that point. So in the meantime, until we have the regs, there's no cliff edge. EIA and SEA still apply. For your reference, section 166 of the LURA, formerly known as LURB, allows EOR regs to make consequential, supplementary or incidental provision, which amends, repeals or revokes any legislation whenever passed or made. So that's the fairly sweeping power that we think will get rid of EIA and SEA. And there's no reason why that couldn't sweep away sustainability appraisals too, which was another question.
Another question I was going to ask about that. So it could get rid of section 19.
Well, I mean, they could revoke anything really under that power, given how it's worded.
Okay. And presumably there'd be transitional provisions for applications that are already in with the EIAs and SEA.
Absolutely, there would almost certainly be transitional provisions, but we don't know what they're going to look like yet. But they will be in the EOR regs themselves.
And $1 million question: how will great crested newts cope?
Well, that's probably the best question, because as we all know, the housing crisis is caused wholly, if not exclusively, by the existence of great crested newts. There's no obvious other barrier to delivering affordable housing. Will this deal with great crested newts? It might do. Certainly possible. You could have an EOR with no reference to newtiness, and if it doesn't have that reference, then you don't need to assess your scheme against it. So we'll have to see how much the government wants to protect the poor newts.
Thank you very much, Nick. Just one question for you, I think. The Dawes judgment you referred us to, where does that leave matters on the ambit of redetermination representations? I mean, it sounds like it's a free-for-all on the back of the Secretary of State's concession in that case.
The honest answer is I don't think this is going to be the last judgment on it, precisely because the Dawes could be seen as a little loose. For claimants, yes, I think they'll certainly see it as an open door to put in submissions on whatever they want. For defendants, the judgment was, of course, based on two things. One is the wording of the provisions, but the other one was specific letters from the Secretary of State. So it might depend to an extent on to what extent the Secretary of State's been sending out letters, making clear representations are being received outside of the matters he asked for. but then for them, I suppose, for the Secretary of State, I suppose after that, it's down to public law irrationality grounds on what he does and doesn't take into account, depending on the representations received. So it won't be an excuse for a do-over, because you can rationally say, what's the point? I decided this already. But
I mean, I suppose somebody who's seeing the reps being very wide on the other side might feel obliged to respond to those very wide other reps.
Quite possibly. So, which is precisely why I don't think it'll be the last judgment we see on that.
That's it, yeah. A possible can of worms there, I think. But I think that brings us neatly to exactly 12:30, which was the end time for today. So I hope everyone's enjoyed listening and they found it informative and useful. Thank you very much for all your questions. As I've already said, the slideshow will be distributed very shortly. So if I can just finally say thank you to all the speakers and hope you have a good afternoon. Thank you very much. Bye now.